Hello, government students. This is Mrs. Politsky, and I have your notes for Chapter 14, Section 1, Selecting Cases at the Supreme Court. So we're going to talk a little bit about the Supreme Court and some of the things that it can do, but there have been some cases that have come before the Supreme Court that have certainly changed the power that the court has. And we're going to focus on a few of these. Some of these might sound a little familiar, especially maybe the last three that we have here on our list. But the first one is Marbury versus Madison. And this is the court case that really established the principle of judicial review when we talk about federal laws. This is a case that kind of goes back to the early days of the courts, shortly after ratification of the Constitution. And it kind of has set the tone. And some people might say it's one of the most important cases that has ever been heard by the Supreme Court, because it kind of has basically established a direction that the court is going to take in the future. Fletcher versus Peck, kind of a similar case, except for it's dealing with judicial review when we talk about state laws. McCulloch versus Maryland, basically is a case that kind of came down to say that states cannot hamper exercise of legitimate national interest. In other words, if there's something that is important for the needs of the nation, a state can't get in the way. Okay. Givens versus Ogden, broaden the meaning of the concept of interstate commerce. Dred Scott versus Sanford. This might be one that you remember back from your history class. This court case is probably one of the more controversial cases that we have ever had go before the Supreme Court. But it basically said that African Americans could not be considered citizens of the United States, or were not at the time. And we're going back to about the 1850s. Anyway, the Missouri Compromise was declared unconstitutional, and it basically said that Congress didn't have any power to stop the spread of slavery. Obviously, that was a problem, and it's really kind of this case that kind of leads us into the whole Civil War. After the Civil War era, we had the case of Plessy versus Ferguson, which is a case that kind of goes back to about the 1890s, but it established the concept of separate but equal when we talk about the relationship between blacks and whites. And it allowed for basically legalized segregation in the United States. It was really kind of, again, kind of like the Dred Scott moment. It was a real downtime when we talk about the courts. In 1954, we had Brown versus Board of Education, and this is the case that overturns the concept of separate but equal, and it ended the practice of segregation by race. For the most part, it's this case that kind of opens up schools, and it opens up eventually a lot of other things when we talk about the issues of race and ethnicity and disabilities and things of that nature. So all of these cases are very important, but the Supreme Court has certain tools that it uses to shape policy. We mentioned judicial review a moment ago. We're going to talk about interpretation of laws and overturning of earlier decisions. When we talk about judicial review, this is the court's authority over state laws as well as federal laws. The Brown versus Board of Education case is a wonderful example of judicial review. Basically, the court held that laws requiring or permitting racially segregated schools in 4 of the states were unconstitutional, and that this decision ended racial segregation for the most part of public schools. Interpretation of law. When we take a look at this, maybe if I can move my box, there we go. The Civil Rights Act of 1964 prohibited discrimination on the grounds of race, color, national origin, and in any program that is receiving any kind of federal money. So if it's receiving government funds, you can't do those kind of things. Law versus Nichols. The Supreme Court interpreted the law to require that public schools provide special instruction in English to immigrant students. In other words, it allowed for classes as English as a second language class. Okay. Overturning earlier decisions in 1928, the Supreme Court ruled in Olmstead versus the United States that wiretaps on telephone lines were legal. But in 1967, the court overturned that decision in Katz versus the United States and basically said that this was a violation of the Fourth Amendment. Limits on the power of the Supreme Court. There are basically four different things here that we're going to talk about. We're going to talk about types of issues the court can accept, types of cases the court can accept, how the court's agenda is limited, and why the courts can enforce its decisions. So, the court, for the most part, can accept cases that are dealing with civil liberty issues, economic issues, issues involving federal legislation or regulation, issues involving due process of law, and issues involving lawsuits against government officials or disputes between governments. Types of cases that the court can accept, cases in which the decision will make a difference rather than simply decide a point of law. When we talk about some of the cases that the court accepts, they usually go for the controversial ones. And if it's a case that sounds similar to maybe a decision that's been made in recent times, they might choose not to accept that kind of a case because they feel like they've just kind of ruled on that in recent times. So, cases in which a person or group are bringing a case that has suffered some kind of harm, cases that involve substantial federal questions, affect many people or operations of political system itself, cases that do not deal with political questions, but it is the business of the executive and legislative branches. So, how is the court's agenda limited? The court can decide only cases that come from it from elsewhere in the legal system, unless it is deliberately taken on as a special case. And then finally, why the court cannot enforce its decision. The president may refuse to execute a court ruling. Lower court judges may ignore or avoid court rulings which they disagree with, and such as the court's ban on school prayer. So all of those can be issues. Thank you very much.